We have at one end of the spectrum, we've got Ravenscroft and Greensboro Day School, where the tuition is 4 or 5 times what a $4,200 voucher can buy. And at the other hand, you have hundreds of unaccredited schools, mostly religious schools. Under the Public Purpose Clause, the legislature can't hand over millions of dollars based on the blithe assumption that anything that calls itself a school is providing a real education. Defendants claim that parental choice is an adequate substitute for state standards, but the state cannot delegate to parents its constitutional duty to ensure that public funds are spent for a public purpose. To make a real choice, parents must have sufficient information, but the voucher legislation deprives parents of basic information they need to assess schools in the voucher market. More than 2/3 of private schools in North Carolina are unaccredited, leaving parents in the dark as to whether the curriculum is sound or the teachers properly trained. In contrast to public schools, private schools are not required to disclose their student achievement records. Schools receiving voucher funds must disclose annual test results only if the school has more than 25 voucher students, a threshold that blocks public scrutiny of more than 95% of schools now receiving voucher funds. And since every school can pick its own test, parents are unable to compare the few test results that are disclosed with other private schools or with the public schools.
Since you're talking a little bit now about the role of the parents, let me go ahead and ask this question. Children in more affluent homes, if dissatisfied with the public school option, it seems to me they have a lot more autonomy and choices. So how do we deal with the children in families of more modest means in terms of the educational choices they may have? Is that at all relevant to this case?
I think it's relevant. I mean, the first thing one does is having some standards so that the schools that they're going to, we have some assurance that they're actually receiving an education. But there's a more fundamental problem, is many of these parents will have no choice at all because voucher schools can choose to deny admission to any applicant. In the first year of the program, 97% of vouchers were cashed by religious schools. Many schools that take voucher funds require the parents and the student applicant, to certify their allegiance to the school's religious doctrine as a prerequisite to admission. In 32 counties in North Carolina, the only school is a religious school. For parents who practice a different religion, abandoning their faith is the only choice that will give their child access to a publicly funded voucher. Because the ultimate choice belongs to the school, not the parent, the students who most need help are least likely to get it. Children who have disabilities, who are learning English as a second language, who have behavioral problems, or who score poorly on tests, all of whom must be served by our public schools, will find the doors closed at most voucher schools. For all these families, the voucher legislation's promise of choice is a cruel illusion. When the state appropriates public funds for education, it must include standards to ensure that the schools receiving the money actually provide an education. If the court chooses to address the public purpose issue, it should hold that the voucher program's absence of standards violates the Public Purpose Clause. The court does not need to reach the public purpose issue to resolve this appeal. The court is bound to enforce the explicit limitation in Article 9, Section 6. Public funds for education must be used exclusively to support the free public schools. And so we ask the court to affirm Judge Hopgood's order and stop the expenditure of funds for this unconstitutional program.